Well, let's get you more on that story now. We're joined by Advocate Romeo Nthambeleni, who is a senior legal analyst. Advocate Nthambeleni, the chair of this committee, has made clear that they effectively don't believe that President Cyril Ramaphosa has a case to answer to and would be relevant for the purposes of this inquiry. What is it going to take for the public protector's lawyers to compel him to give evidence?
Look, I think you started it correctly there in terms of compelling the president to come and give evidence. Let's first understand the relevance of the president's evidence in the commission. In labor law, if the person has appointed you to the office to actually do your duties, that person can be called to come and testify. But the president did not appoint the public protector. National Assembly did that. So in terms of his relevance to come and give evidence, there's no relevance whatsoever, because he was the public protector's office is being appointed by the National Assembly, and that's where she's actually answering the questions in terms of Section 194 inquiry. So there's no relevance whatsoever on the president coming to give evidence in the inquiry when the president himself is not an employer of the public protector. The public protector serves under the Constitution, and she's appointed by Parliament, where she's answering in terms of the Section 194 inquiry.
Of course, what we can't shy away from is that the president has been involved in ongoing litigation with the public protector, and is as a result of some of that litigation where, she has been unsuccessful, and the courts have found that some of her judgments were not sound, that also relate to the president.
Indeed, Kathy. I think the issue of the courts have been settled by the decision of the Concord in relation to the CR17, that you are actually referring to say that the public protector did not have framework to do that investigation. The current issue relates to the para that you're actually referring to, which the current public protector who's sitting in the office is currently dealing with that, and I think that should be separated. So the issue of the public protector investigating the CR17 campaigns has been dealt with by the court, and the court has actually settled it. And what remains now is the current public protector to actually continue with the investigation in the absence of the suspended public protector, which she's currently doing. And I'm sure you're well aware that there is an imminent subpoena that has to come out against the president to come and answer the questions in relation to the questions that were put by the previous public protector.
The fact that there is this perceived tension between the public protector and the president, is that not something that needs to be ventilated?
It can be ventilated, but the Parliamentary Forum, Section 194, is not the right forum, Kathy. It can be ventilated in other ways, but not by summoning the president to come and appear in the inquiry, when the terms of reference has got nothing to do with the president appearing there. The president is not the one that is saying that the public protector is not fit to hold office. There are people that are going to give testimony, to actually conduct that the president, the present public protector is not fit to hold office. So that can be another forum to actually ventilate those issues that we are talking about, but not calling the president to come. It creates the conflict of interest in relation to the separation of powers in our Constitution. And the separation of powers is very clear in terms of what it says about the executive and the judiciary.
Senior legal analyst, Advocate Romeo Nthambeleni, will leave it there for tonight.